G'day everyone, and welcome to video 4.1.4 from the Legal Studies Guide. Today we have possibly, I think, the favourite quote I've used so far. A bit more of a fun one, I suppose, than some of the ones we usually use. I think of dieting and then I eat pizza. If you are one of those people watching who doesn't like pizza, then you are dead to me. Pizza is possibly the greatest invention known to mankind. So thanks to Lara Stone for that one. Video 4.1.4 is what we are looking at today. It's a pretty dense one. It's one of those ones that's got some 5 extra dot points to go through. Or 5, sort of like a list of things we need to know. So we're looking at the means, and lists the means for us. So the means are these 5 things by which the Australian Constitution acts as a check on Parliament in lawmaking, aka how does it restrict Parliament? And it gives us 5 ways in which Parliament is restricted. So Parliament is restricted by the Constitution through the bicameral structure, through the separation of the legislative, executive and judicial, through the express protection of rights, through the role of the High Court, and through the requirement for double majority in a referendum. So it gives us 5 ways in which the Constitution restricts Parliament. But particularly important is the skill, which we'll talk to at the end, where we actually have to evaluate the ways in which the Constitution acts as a check. So evaluate, as we know, and we'll talk about a little bit more at the end, is come to a value judgment on does it or doesn't it, or somewhere in that scale, and have evidence supporting that. So we're going to have to look at both how these things here do restrict, but also how they might not restrict. So our essential question that we'll be able to answer at the end is, how does the Australian Constitution act as a check on the lawmaking of Parliament? And we'll also be able to answer a bit of a sub-question to that, which is how doesn't it? So a quick question to consider, and why this dot point is important. Why do we need a check on lawmaking? So have a little think about that. Why do we need to put a check on Parliament? And hopefully the first thing that popped into your head is this idea that we do need some restrictions in place on Parliament to make sure that they essentially don't stuff us around. Like, as much as we'd like to say that the people who govern us are going to make good decisions on our behalf, world history very clearly shows that it's only a short walk until you end up with a dictator. It's only a short walk until you end up with a group of people who are going to only make decisions to benefit them and not everyone else. So with that in mind, we need checks on lawmaking. We need restrictions on what Parliament can do to make sure that we, the people, aren't taken advantage of, to make sure that we, the people, get a government and a country that is acting in our best interests and not the interests of the people in charge. So how do we do it? Starting with the first one listed, which is the bicameral structure. So just a quick note on structure. Each of the 5 things, the slide will simply look at this like this. What is it? We'll explain what it means. So what do the words actually mean? And then how does it actually put a check on Parliament? So how is it a check on lawmaking? So that if you're asked, how does the bicameral structure of the Australian Parliament put a check on lawmaking? You'll be able to explain. From dot point 4.1.1, you would hopefully remember this term bicameral. It means a parliament with 2 houses. So as we know, in Australia, we have the House of Reps and the Senate. So this little structure here, the Governor General at the top, but we have the 2 houses down the bottom, 1 and 2. There are some parliaments that only have 1 house, particularly in Australia. That includes Queensland. Queensland only have a lower house, so the government gets to pass whatever they want, so just 1 house. So parliaments can be unicameral, but our Australian Parliament is bicameral. And each house has a different voting method, and by voting method I mean in elections. So they're voted in different manners. So not a different voting method in each house. That's the same. You just agree or don't agree on a potential law. But each house has a different voting method in elections. And we'll talk about how that acts as a check. Basically, by having this different voting method for each house, one party rarely achieves a majority in both houses or coalition. So we know that in the history of Australia, there's only been a majority in both houses twice, most recently in 2004. So what the Senate uses is what's called proportional voting. And it can be tricky to explain, but I'll try and give you it in the briefest, simplest way possible. When we're voting on the House of Reps, it's a simple, you get a list and you number them 1, maybe 3, maybe 2, in order of preference. So 1 through to 5 if there's 5 on the list. And basically they get all your votes and they put all the number ones for one candidate in a pile, all the number ones for the next one in a pile, all the number ones for the next one in a pile, until they've got 5 piles. And they count those piles, and if one of those piles gets more than half the votes, that person is the candidate. Simple. But if all those are under half, so no one got more than half, well, they figure out who got the least number of votes, which would be this one here, and they take all of their votes and they redistribute them based on who those people gave number 2 to. So some more to that pile, some more to that pile, some more to that pile. Then they'll recount, see if anyone got half. If at that point someone does have half, they become the candidate. At that point someone doesn't, they take out the next lowest person, maybe there, and they redistribute those votes again until they get to someone with half. So preferences do matter in the House of Representatives, but as a general rule, you are most likely going to end up with someone from one of the major parties, because preferences, they're going to get the most number of votes initially, they're not going to be knocked out, and eventually preferences are going to flow to them. So either Labor or Liberal, in some seats the Nationals, and in one seat the Greens. There are a couple of prominent independents around Australia, so people who don't have a political party, who just get lots of votes in their local area. But as a general rule, it's far easier to get elected to the House of Representatives if you are from a major party. On the other hand, in the Senate, you get, how do I put this? The political parties at the top of the page, and then a list of their candidates below it, because we are electing 6 people each time. There might be 3 here, there might be 2 there, might be 4 there, and that list can be this long. I don't know if I can even stay in shot there. It can have, 20 plus names or parties at the top. It can have up to 100, and I think they've had over 100 candidates for the Senate down the bottom before. And it's changed recently, so if you want, up the top, you can just number 1, 2, 3, 4, 5, through to 6. But if you want, you can actually give everyone numbers down the bottom, all the way through to 100, 115, 120, however many people there are. Obviously, this gets significantly more tricky when we're electing 6 people. And what actually needs to happen is, say you've got 700,000 people. This is where I'll potentially lose some of you. Say you've got 700,000 people. They divide your electorate into 7 equal portions. Or they don't divide it into equal portions, sorry. They just divide the 700 people by 7, which equals 100,000. And then in order for you to get elected into the Senate, you just need to get 100,001 votes. Okay, if 6 people get that, then the next candidate, the 7th candidate, will have less than that number. So what they're trying to make sure is that they don't need 50% of the votes to get in. They just need their portion, which is it works out to be about 12, works out to be just under 14, or just over 14% of the vote, I think. So naturally what happens in the Senate is the major political parties, so Liberal and Labor, very, very easily get 14%. So say in this example of 100,000, they might get 200,000 votes. So what they then need to do is they need to redistribute 100,000 of these to other candidates because obviously that first person's already got the 100,000 quota. To do that, rather than just randomly pick 100,000 of those extra votes and redistribute those, they redistribute every one of the 200,000 votes, but they only redistribute them at half value because they can't accurately work out which votes elected the person and then which votes were excess. So all of a sudden they would redistribute 200,000 at 50%, another 100,000. Most of them would go to the next Liberal person, they'd get elected. But all of a sudden there's no extra votes there. And there's no extra votes to go to the Liberal candidate. So we start counting all of these votes, all of these random 4s and 5s and 6s. And as a result, and I know I've probably kind of ran you around the block on that one and not got a really clear picture of it for you. But as a result, lots of minor parties get elected. So it's far easier for the Greens to get people in the Senate than it is the House of Reps, and they have, I think, up to 9 senators. One Nation had a few senators. It's easy for independents to get elected. Famously, after I think it was the 2013 election, a guy in Victoria called Ricky Muir got elected from the Australian Motoring Enthusiast Party, and he ended up on first preferences, so people who put a 1 next to him, less than 100 votes. So less than 100 people gave him the number 1, but once all these preferences started flowing around at the end, he got up to enough votes to meet the quota. There was a guy in Queensland Western Australia, who had about 30 votes, I think, and the same thing happened. So this proportional voting, and this is how you need to explain it because it's obviously very detailed. This proportional voting in the Senate provides greater opportunities for minor parties. And as soon as you've got more minor parties, you've got less seats going to the major parties, you've got less chance of them having a majority. That means bills or legislation has to be debated, it has to be agreed upon from multiple viewpoints from multiple political parties, ensuring one party cannot abuse their lawmaking power. 2004 is a great example. John Howard and the Liberals get elected with a majority in both houses. And one of the major law changes that Howard makes is a thing called work choices. And it passes both houses easily because they control both houses. And work choices, in an absolute nutshell, gives more power to employers to fire employees. Lots of other stuff around it about, poorer working conditions, but basically gives business more power over their employees. And the Australian public hates it. Howard is able to pass it through even though it's not a good law, it's not a good change. And when 2007 rolls around, he gets voted out pretty heavily in favour of Labor Party and Kevin Rudd, so Kevin 07. So that's one example, though, of the fact that we had those laws for a couple of years because one party didn't so much abuse their power, but could make a really poor decision. The other thing is you've also got 6-year Senate terms. So in 2004, the Liberal Party was really popular. Heaps of Liberal senators were elected. They stay in until 2010, even though the political views of Australia had changed somewhat by 2007. So that means there's still a greater spread and less chance that you'll get a majority, which means, again, legislation must be debated, agreed upon from multiple viewpoints. The separation of powers. So separation of powers is a concept that was originally theorised by a French guy hundreds of years ago, And it's a pretty accepted doctrine for democracy around the world. And this is the idea that we split legislative power, executive power, and judicial power into three separate bodies. Okay? So they are in Australia the legislative power, which is the power to make laws, which is with our parliament. The executive power, so the power to administer laws and manage the business of government, which is the Governor-General, but in practice carried out by our government and senior ministers. And the judicial power, so the power to settle disputes arising under the law, aka the power to interpret the law and decide if someone's broken it or not. This rests with the High Court and other federal courts, and in the states with the state courts in each state system. Why is this important? Why do we split up the power to make laws, the power to then administer the laws, and then the power to adjudicate on or decide if you've broken them or not? And the main reason is we want to prevent power from being concentrated in one body. We want to make sure individuals' rights are protected by making sure that no one can abuse their power. I want you to think perhaps if you were a dictator and you had control of both lawmaking and judicial power, so power of adjudicating over the laws. If you had a political opponent you didn't like, if you had a person at all that you didn't like, you could literally pick out one of their behaviours, make a law that says that's now illegal, and then straight away administer the law by arresting them, and then you have the power to adjudicate on the law and decide that whether they've broken it or not. So it would be very easy if you were a dictator and these powers weren't split, weren't separated, for you to basically cherry pick and charge anyone you didn't like with criminal offences, get anyone you didn't like locked away in order for you to more effectively control the country. So it's very, very important that we have a separation of powers to prevent any misuse or abuse of power. So a bit more of a straightforward one. Express rights protection are another way in which Parliament is restricted by the Constitution. So express rights are rights that are explicitly written into the Constitution. So they're listed in the Constitution, they're enumerated in there. They are entrenched, they can only be changed through a referendum, section 128. We have 5 express rights, as I just said. They are a limited freedom of religion, so the government can not make any law that restricts worship. They cannot establish a state religion, and they can't restrict worship, and they cannot establish a state religion, but they still can potentially discriminate against you based on your religion. So the law or the section of the Constitution doesn't read as you can't be discriminated against based on your religion. It's not a full absolute freedom of religion. It's just a limited freedom of religion where your worship, you can't be restricted from your worship, and they cannot establish a state religion, and they can't make you have to be a certain religion in order to hold government office. So they can't force you to be Christian in order to work for the government or to be in Parliament. So a limited freedom of religion, they can technically still discriminate against you based on your religion though. Section 117, again, no discrimination, but this time based on your state of residence. So for all those 2-headed Tasmanians, we can't discriminate against them. Free interstate trade and commerce. So big at the time of federation, when the colonies had their own separate economies, was this idea that all of a sudden trade would have to be free between them. Not as relevant these days because it's kind of accepted practice. The section from the castle, the right from the castle, that if the government acquires your property, they must give you just terms for it. So this means both that they have to give you appropriate monetary value for the property that they're acquiring, but also can only do it with valid reason. And then you've got finally Section 80, which is if you are charged with a Commonwealth indictable offence, you get trial by jury. You cannot waive that right. You must have a trial by jury. But this is, again, not an absolute right to a trial by jury, because if they want, the Commonwealth can just change things to be summary offences instead of indictable offences. So it's only a limited right again. But how do these 5 things put a check on Parliament? How do they restrict Parliament's lawmaking? Pretty simple. Parliament can't make a law that breaches any of these rights. If Parliament make a law that, breach your limited freedom of religion, the High Court is able to declare it invalid. So the Parliament can't make laws that breach these 5 express rights. Therefore, restriction on lawmaking. The role of the High Court, and the questions here are the same, but I've just included a picture of the High Court there. So what role does the High Court play? Well, as per the separation of powers, the High Court is independent of Parliament and government. So people are appointed to the High Court as judges, 7 justices of the High Court. They're appointed by the government, but then they cannot effectively be fired unless they break the law. So they're in there until they're 70, regardless of what happens. So they're independent of Parliament and government. Parliament and government can't get rid of them if they make a decision that they don't like. The High Court has the power to rule on all matters involving the interpretation of the Constitution. So anything to do with the Constitution dealt with by the High Court. They decide what the words in the Constitution mean, not the Parliament, not the government, the High Court. This means they have some really, really cool powers around restricting lawmaking. One is if any law or legislation breaches the Constitution, the High Court can declare it invalid. So they can actually strike out legislation that breaches the Constitution. The High Court also has the power to find new rights in the Constitution. So rather than those just 5 express rights, they can actually go and look through the Constitution. If someone brings a case only, they can't do it of their own volition. And they can find new rights, and these are known as implied rights. Australia has only one implied right found by the High Court, which is freedom of political communication. This case will come up again when we talk about Section 7 and Section 24, but it's basically the government passed a law that said that in the 6 months leading up to an election, those political ads on TV, for example, are restricted. You basically can't run political advertising because they were worried that the parties that had more money would run more advertisements and then were more likely to get voted on, and it wouldn't be a level and fair playing field. But a TV station took that to the High Court and said, well, how do you expect people to make a proper judgment on who they're going to vote for if they can't get any actual information? And the High Court agreed and said, based on Section 7 and 24, which we'll read later on, for the public to vote appropriately, they must have the right information, and therefore we need freedom of political communication. So that is a right that the Parliament cannot breach. Finally, double majority. Double majority provision is part of the referendum process. So if we wanted to actually change the Constitution, to remove any of these restrictions, for example, the process for that is included in Section 128 of the Constitution. And part of the process includes a yes-no vote from the public. Okay? So everyone in Australia who's an eligible voter votes either yes or no on the change. And this change must achieve a double majority, meaning a majority of people overall, so including the territory, so if there's 20 million voters in Australia, 10 million and 1 must vote yes. But also, it must achieve a majority of voters in a majority of states, aka more than half the voters in 4 out of 6 states have to vote yes. So half the voters if there's 2 million, more, if there's 4 million voters in Victoria, 2 million and 1 have to vote for it. New South Wales, if there's say 7 million, 3.5 million and 1. WA and South Australia, maybe 2 million each, 1 million and 1 in each of those. So each 4 of the 6 states have to have half of their voters vote yes. What this is and why they put this in is they were concerned at Federation in 1900 that if they wanted to change the constitution, because Victoria and New South Wales have such a large population compared to some of the other states, particularly say Tasmania, they were worried that the people of Victoria and New South Wales would just be able to vote through changes to the constitution that benefited them and didn't benefit the smaller states. So they put in this provision that said over half the voters in 4 out of 6 states must agree. Basically, it's just a restriction because it means that any change has to have broad public support. It cannot just be supported by 2 larger states. Everyone across Australia has to support it. And historically, it has proven really, really strong as a protection. So only 8 of 44 referendums have been successful. We've had 44 referendums since 1900 and only 8 of them have got over the line. And there's been 5 of those that didn't get over the line that actually got a majority of voters overall. More than half of Australia voted yes, but didn't receive a majority in a majority of states. So the double majority provision does work at restricting lawmaking or restricting the ability of Parliament to just change the Constitution to suit their own means. Our skill here today, as I said, is we have to evaluate the ways in which the Constitution acts as a check on Parliament in lawmaking. So the question could be as simple as evaluate the ability of the Australian Constitution to act as a check. So when we evaluate, we have to give, and the word is in there, we have to give a value judgment, aka does it definitely restrict or does it not restrict? And we have to have a value judgment that sits somewhere on this scale. So maybe we sit here and then we have to provide evidence that shows how we ended up at that value judgment. So for making a value judgment on how the Australian Constitution acts as a check on Parliament, we can use this evidence. Basically, these 5 points here are the 5 we just went through. The High Court can find new rights. They can declare laws invalid. A political party rarely has a majority in both houses. Separation of power ensures no one body holds absolute power. So that's how it is a check. But we also need to know now how it isn't a check. And this is important. The High Court can only declare laws invalid if someone with standing brings a case. We'll learn more about standing in 4.2, but this is important. It means you can only bring a case if you are personally affected. So Parliament can make laws that breach rights. They're not restricted from actually making the law. It's just that someone would then have to bring a case to declare it invalid. With the separation of powers, the executive and legislative branch are not completely separate. Members of the executive, so the Prime Minister and the senior ministers, actually sit in Parliament, so they're not completely separate. This is as opposed to the American system, where the president, the executive, the president who runs the country and administers the laws, Donald J. Trump at the moment, he is not a member of Congress. He is separate from Congress. Congress makes the laws. Once the laws are made, he then decides how they're implemented and which ones are focused on, etc. So he doesn't actually have absolute power in America. He would appoint people to be his Secretary of State, which was originally Rex Tillerson. He appoints people to significant positions like ministries or secretary positions in the United States. They are, again, not members of Congress. They are just people who are the best candidates. In Australia, though, to become the Minister for Finance or to become the Minister or the Foreign Affairs Minister, you have to be a member of Parliament. So we have crossover, which means there's potentially some room for abuse of power. Express rights are limited both in number and scope. We only have 5 and they're pretty weird, like not being discriminated against based on your state of residence, as opposed to broad human rights like the US Bill of Rights that protects freedom of the press, the right to bear arms, however you feel on that. So Our express rights are really limited, so they're not really much of an actual restriction. There's only one implied right. And it is possible, even though it's rare, it is possible that one party could achieve a majority in both houses, like Howard in 2004 with the work choices laws. And then the bicameral structure is not a check at all, like if you've got a majority in both houses. Just head up, make sure you're checking out the Parliamentary Education Office website. It is fantastic. It has information on all of these things. It has fact sheets, etc. Using them with my Year 7s a little bit at the moment, which is going really, really well. Ultimately, apart from probably the voting system for the Senate, which was very confusing and I blathered my way through, hopefully you can say, after watching this, how the Australian Constitution does act as a check on the lawmaking of Parliament with confidence. Hopefully you can also evaluate it how it doesn't and look in a bit more detail at that side of things. This has been another video for the Legal Studies guy. I hope you're having a wonderful end to Term 3 or wonderful preparation for exams if you're watching this at the end of the year. Make sure you subscribe, like the Facebook page, and we'll talk soon.